Good day. This is Dave Henry. I'm the owner and operator of Henry Mediation. This class is called Casting Light on the Dark Art of Mediation. It's approved for 2 hours by the Board of Bar, including a half an hour of CLE. The course number is 250-740-6N. And I hope you'll stay for the entire program. I want to tell you quickly about myself. I'm a 30-year litigator in Orlando, did a wide variety of civil cases, a lot of insurance defense, but also some intellectual property, legal malpractice, other forms of non-medical malpractice. Had a stint as an aviation lawyer for a while, did some aviation accidents and some heavy products. So I've seen a whole bunch of different kinds of cases, which is not necessarily a great career path, but it helps you as a mediator when you've touched a handful of different things. And over the past 30 years, I've developed this program, which is intended for lawyers who want to get better at mediation and for clients and carriers and risk managers and folks that participate in mediations. I think mediation is an underappreciated art. I think it doesn't get its due in the civil justice system. I think mediation provides access to justice in a way that the trial system really can't. We don't try that many cases anymore. And we didn't, even before the pandemic, the rate of trial was less than 2%, and now it hovers around 1% by most commentators say around 1% of the filed cases. So if we're not trying a lot of cases, that means we're settling a lot of cases. And if we're settling a lot of cases, we need to get good at it. We want to have efficient settlements. If you're a plaintiff, you want to maximize recovery. If you're a defendant, you want to minimize exposure. And that's what I try to do in these seminars, is set the table, give you some ways of approaching mediation that are different than you heard before. A lot of what gets done in mediation, in my view, is unexamined habit and ritual. And I'm not a fan of unexamined habit and ritual. I spent a lot of time thinking about how to optimize the mediation process. What are the things we can do, whether we're plaintiff or defendant, to put ourselves in the best position to get the case resolved on favorable terms? And that is not an easy thing. And it's not an easy thing to talk about. It's not an easy thing necessarily to get your brain around, because mediation is one of the most unlawyerly things that we do. It doesn't require knowledge of case law, rules of evidence, procedure, how to handle expert witnesses, the nuances of the evidentiary rules, closing arguments, opening arguments, amassing discovery, pleading. It doesn't, all the things that trial lawyers do or learn, practice, and hone, those skills that you hone to be a trial lawyer, don't really have much application in the mediation process, because the mediation process is making a deal with your adversary. And we don't do that in the trial. Trial process is amassing evidence to put in front of 6 or however many disinterested neutrals, disinterested jurors, to convince them in some sort of positional debate of the legal and moral benefit of your position, the legal and moral sense of, not betterment, I suppose, but the superiority of your position, right? And in mediation, we don't do that. Mediation, we're talking with our adversary in an effort to make a deal. It's a very different skill set. And it's hard to talk about mediation and get good at mediation and talk about, well, what are the things we're supposed to do? Because it's not rule driven. So much of what we do as lawyers and trial lawyers is rule driven. There's rules of civil procedure, there's rules of evidence, there's rules of professional conduct. There's rules about where you can stand in the courtroom. There's rules about when you can speak to what you can say to the judge and what you can't. There's rules about how you can talk to the jury and what you can't say in front of the jury. There's a whole myriad of rules. And in mediation, there really aren't any. I mean, the only rule is it's confidential and privileged, and pretty much anything you can say pretty much anything else you want to. I mean, there's a handful of exceptions, but none of which are likely to apply. But so it's not a rule-driven thing. And you step back from that, you go, it's not a rule-driven thing. It doesn't require my skills as a lawyer per se. So what are the things that I need to do to be able to get good at being a mediation advocate? That's the word I like to use, is mediation advocate. So there's trial lawyers, and then there's mediation advocates, right? Trial advocates and mediation advocates. And I don't think it's enough to be good at trial anymore. I think you're doing your client a disservice if you view mediation as sort of a perfunctory, well, we've got to check the box and we've got to go do that. And if we settle the case, okay, so that's great, fine. But if we don't, we'll go to trial, and that's really the main thing. It's not the main thing, because trial only happens 1% of the time. Mediation is the main thing. Mediation is the way cases get resolved, at least in the state of Florida and increasingly elsewhere. And so if we're going to do, and we do mediation, what, 90, 95% of the time? in our civil cases. So that's the thing we need to get good at. But getting good at mediation is not necessarily an easy thing, because mediation occurs in a cloistered environment. I mean, this seminar says casting light on the dark art of mediation because it is a dark art. It occurs in a black box. You don't get to know what was spoken or said unless you actively participate. There's no transcript, there's no recording, there's no writings. And that's very different than the other things in the law, right? Because we have deposition transcripts, we have trial transcripts. Trials are sometimes even televised. And so there's feedback mechanisms along the way when you have recordings. You can read something and say, oh, that's not right, or that was done wrong, or that's error, right? We have appellate courts that can point out error. That's a feedback mechanism. A judge denies a motion, that's a feedback mechanism. Your client doesn't pay your bill, that's a feedback mechanism. We don't have a lot of feedback mechanisms related to our advocacy and mediation. Either we came out with a deal or we didn't. But we don't really spend a whole lot of time talking about, well, why did this case impasse? What could we have done differently? Where's the post? We don't do a lot of post-mortem on why this deal didn't get done. What are the things we could have done in advance? Was there some information that didn't get transmitted? What could I have done differently that might have led to a better outcome at the mediation? That's what this seminar is all about. And so thank you for coming along board. So we know that mediations are here to stay. We know trials are very rare. We know it occurs in a black box. It's a cloistered proceeding. So there's the problem with mediation, as I see it, the sort of 30,000-foot problem, is that it's not value affirming. There's no winners or losers. Nobody's reputation is built on mediation advocacy. Nobody's career, it's not a career enhancing in any real meaningful way, like a trial might be. So it doesn't get the same light. It stands in the shadows of the trial practice. And I think we got to put it in the light, that we need to make sure we understand how important it is to the process. If we didn't have mediations and we couldn't get cases settled, our court system would be even more backed up than it is. So it plays a hugely important role in the whole civil justice system. I mean, I can't even imagine a system without mediation. All those cases backed up, or people trying to settle them without the benefit of mediation, which we did. I mean, before the Mediation, Confidentiality, and Privilege Act, which was passed, I think, in 1985, I mean, lawyers did settle cases, but mediation's become the best vehicle for doing that. So it's here to stay. A couple other things I want you to think about. An impasse is not a failed mediation. That's one of the things that all mediators agree on. If you go to a mediation with me or a competent mediator, you should walk out of that mediation, even if you don't settle, knowing more about your case, more about the other side's case, figuring out something new, putting yourself in a better position to try the case. And confirming what you think was already the case is also not a bad thing. Not learning anything new, or figuring out, well, I didn't hear anything I hadn't heard before. There's a certain comfort in that too, right? Now I have more increased confidence in my strategy and in my approach and in my trial and my decision to take this matter to trial. So I think there's there's a psychological benefit for your client too, because your client wants particularly if you're claimant's counsel, the client wants the story told to somebody, and mediation can provide that cathartic release for them. Now if you impasse, you're going to tell the story again in front of a jury, but the plaintiff likes the idea of you, the plaintiff's attorney, telling the story to the mediator and to the other side. And they like that. That's beneficial. And the defense benefits from mediation in a number of ways, because if you're a defendant and you represent institutional clients, whether it be insurance companies, corporations, whatever it might be, on an ongoing basis, this is an opportunity to solidify this relationship. This is an opportunity for you to spend time with that corporate representative that you wouldn't otherwise get in the ordinary flow of litigation. So I think you need to really be thinking about mediation as a client development opportunity. It strengthens the client bond. If you do a good job, even if the case doesn't settle, if the client has the sense that you've done a good job, you've prepared well, you're on point, you're making the great arguments, you're working with the mediator collaboratively to try to get a deal done, they appreciate the effort getting the deal done. That's what lawyers hear from clients, is I appreciate the effort in trying to get the case done. That solidifies the relationship, and that can lead to more business. I think mediation is a client development opportunity if you represent institutional clients. It's huge. And we don't necessarily appreciate that. We don't think about that. But where else are you going to spend 5, 6, 7, 8 hours with a client cloistered away or on a Zoom call you're not. And so you really need to think about that as a huge client development opportunity for you. What are the challenges in the path of improving mediation advocacy? Well, I should say, I should have said this at the beginning. There's an outline on the website. So if you go to Casting Light on the Dark Art of Mediation, next to it, you should see a PDF with the outline. So you can get that outline and follow along. That might be helpful. The incentives are somewhat misplaced because if we settle cases, then lawyers that are getting paid by the hour render themselves unemployed. So there's an incentive problem there. Uh, and mediation isn't really revered in the public eye because they don't really understand it. They can't. There's no recordings. You don't do television shows or movies based on mediation. So because it's not value affirming, there's no great stories. There's no big winners and losers. These are all impediments to getting people to appreciate, and lawyers too, to really appreciate the important role mediation plays. Only a trial lawyer wants a trial. You have to remember that. Truth story. Let's talk real quickly about selection of the mediator and timing. We could do an hour on that. And in fact, what we do, this Casting Light seminar is an introduction to a larger 5-hour program called the Mediation Mastery Series, where we do a deep dive into a bunch of different kinds of issues. For example, dealing with carriers, or if you represent governmental entities, and we deal with settlement agreements and motions to compel settlements and problems with settlement documents. And we deal with opening statements and position statements and a whole bunch of other pieces and parts of the rules, attendance rules, myths and misadventures. So there's a whole treasure trove of material in that 5-hour program called the Mediation Mastery Series, which is also on the Henry ADR website. And I would encourage you to get to that after this seminar. All right, so mediator selection and timing. Sponsorship theory says you want the mediator that the other side likes and trusts, because at the end of the day, if that mediator is viewed as a trusted speaker, then your message carries more weight, right? You want the mediator to say, oh, that's all the money they've got, or I think this is as low as they're going to go. And you got to sort of kind of believe that. And if you don't, it's really hard to make a deal. So you want the mediator that the other side wants and trusts. So I always defer when I was a litigator. I always deferred to the other side, unless I had had some really horrible experience with some mediator. And I knew the track, which is pretty rare. I almost always deferred to the plaintiff's choice, because as a defendant, it wasn't really going to change my analysis. But if they felt better about the process and they had confidence in the mediator, great. That just makes it easier for me to get the case settled. Timing is another thing. So let's talk about mediator selection and timing. First of all, think about the participants in the mediation and who do you want as a mediator? If it's a sexual harassment claim, for example, I did a lot of employment law back in the day. I'm not, and the sexual harasser is a 60-year-old white male that looks like me. I'm not sure you want me as your mediator on that claim. You might want somebody else. Or maybe you want a female mediator. If you're the defendant, you want a female mediator, talk to the female plaintiff. You got to think about that a little bit. If it's a case involving theological seminary issues like pastoral abuse or something like that, you got to think very carefully about the personalities that are going to be in the room and how is that mediator going to play in front of that audience. If it's a construction case, that cast of characters looks a little bit different than if I'm doing a medical malpractice case, or if I'm doing an HOA case. I'm getting a different slice of humanity there. And I want to think very carefully about who I'm putting in front of that group, and managing my own client. If I have client problems myself, if I can't manage my own client's expectations, can I pick a mediator that can help me do that? And so those are the sort of things that I would think about when I was when I was actively involved as a litigator. Timing is a funny thing. Mediations occur too late often. And the reason they occur too late is because when mediation first came on board as a judicially mandated thing in the late 1980s, so the Mediation Confidentiality and Privilege Act is passed in 1985, 86. And so it becomes then in the court orders, we start seeing court ordered mediation in the late 80s and early 90s. And those court orders would typically have the mediation deadline at the end of the discovery period, or 30 or 60 days before the pretrial conference. So the mediation was always back end. It was always the back end of the trial order. It was always the back end of the process. And there was no good explanation for that. The reason it was done that way is because early on, some judges had some concerns that the trial bar was going to look with sort of a jaundiced eye at mediation. And so they didn't want to make mediation the first order of business in a lawsuit. And so they sort of shifted it, sort of shoved it off to the back of the process, sort of the tail end of the process, so that it would be sort of psychologically more palatable to the trial bar, because there was a fear it wasn't going to be well embraced. That's also why you saw in some of those in the mediation orders, the court orders, it would say lead trial counsel, because the courts wanted the mediation process to be taken seriously. They didn't want to look at it so you send some lower level associate off to go do the work. They wanted the lead trial lawyers at the mediation, so they would take the mediation process seriously. Well, the funny thing is those two things still exist. You still have mediation deadlines at the end of the discovery period or the eve of trial, and you still have language in those orders that says lead trial counsel, when in fact, lead trial counsel may not be the best person to come to mediation. The best person to come to mediation is the person who's good at making deals. That might not be the lead trial counsel. Lead trial counsel may not be good at making deals. They may be good at trying cases, but deal making may not be one of their strong suits. So you should choose the advocate that's going to do the best job for the client, right tool for the right job, right? So you've got to find the right tool. And lead trial counsel may not be it, but the orders say that, but not because, and to mandate who comes is sort of silly, because the whole point of mediation is self-determination, right? That's sort of the mantra of mediation in Florida, is that we let the parties sort of self-determine the outcome and self-determine the process. And so when you tell them who they have to bring, you're sort of monkeying with one of the fundamental principles of mediation, which is self-determination. So bring who you want to bring, and set your mediation at a time when you have enough information to mediate effectively, but you don't need all the information in the world. You don't need a ton of depositions to mediate a case. You might want a bunch of depositions to try a case. You might want expert depositions to try the case, but you don't need expert depositions necessarily to mediate a case. You don't even sometimes need the plaintiff's deposition to mediate the case. If I got a wrongful death claim of a baby, I don't necessarily need to take the plaintiff's deposition in order to get that case mediated. I don't need to put them through that necessarily. I'll need to wait a year to mediate that case. There's lots of cases that get mediated too late, and they get mediated too late partly because the court orders have sort of created this culture where the mindset is, well, the mediation is going to come at the end of the discovery period. And there's a lot of problems with that, because people become more polarized. You have sunk cost problems. How many times have I seen cases where someone's litigated, spent $30,000 or $40,000 on a piece of litigation, and it's not it's barely a six-figure. If it is a six-figure settlement, you've eaten up the amount in controversy by a fair chunk of the legal fees and costs. So you really need to think about mediating earlier, but we don't do that, and judges don't help. And I write a lot of articles and talk to a lot of judges about doing just that and getting these cases into mediation. If it's a significant case, you want to plan on two mediations, one early in the life of dispute and one down the line. Why wouldn't you have two mediations in a significant case? Why wouldn't you want to give those clients an opportunity to avoid trial? Oftentimes in a significant case, you can get if you're a defendant, you can get out quicker and easier if you settle out early. If the plaintiffs invest a lot of money in the case, it just makes it more expensive. And feelings can get bruised, or you can get emotions. People get upset, people get polarized, people get really annoyed during the litigation. Litigation doesn't tend to bring people together, it tends to polarize them. So deals become harder later in the life of the case, because sometimes you have less options. So I urge you to think really hard about getting the cases into mediation earlier in the life of the dispute. I mean, within like 90 or 120 days of joinder of the parties. The question you have to ask yourself is, what is the least amount of information we need to mediate? What is the least amount of information we need to mediate? That's different than, well, I work up every case if it's going to trial. Well, you can do that, but that doesn't make a lot of sense to me, because only 1% of the cases is going to trial. What I would do is work up the case in a way that gets me the information I need to mediate. And that's different than the information I need to try a case. It's a small sample of the information I need to try a case, right? You don't need to read the whole newspaper to try the case. You can, to mediate the case. You could mediate a case just based on let's give me the headlines. That's all I need. I don't need the whole newspaper. So I think people don't want to mediate early because lawyers don't like it because they feel like they don't have all the information. So they don't feel as confident in their recommendations. They feel like maybe they can't handicap the case as well as they would like to if they don't have all the information. But all the information comes at a price. Comes at a price for your client because the resolution is delayed if you're a plaintiff. It comes at a price for the defendant because they have unresolved conflict and continuing legal bills. So there's a price, and the reality is everybody makes decisions based on imperfect information. Nobody has perfect information. You're not, and the carrying cost, the time and expense associated with getting that information makes it not necessarily worth the time and the effort. You don't need a ton of information to mediate the case. The clients don't, they're not asking for you, they're not asking for the mediation to be at the end. They're not asking for that. They'd rather get resolution sooner. And if it doesn't resolve early on the process, you can set another mediation later on. Because usually one or both parties want to get off the bus. Usually the one or both sides don't want to go to trial. They may say that they do, but they really don't. And so you give them the second mediation because sometimes what happens during the life of the dispute, somebody runs out of gas, somebody runs out of interest, someone's got a life situation, a marital situation, a kid situation, a job situation that makes trial for them extremely burdensome. And that may have arisen during the litigation process, and now we got to deal with it. So if we have that second mediation built in, you get that get out of jail free card, so to speak, in your back pocket. You don't have to come asking for the mediation at the end of the discovery period if you've already planned for a second mediation at the beginning of the case. And that's what I did the last 10 years of my career. I would always tell folks that we're going to have two mediations. If it's a significant, and I say significant case, I mean amount in controversy, $200,000 or $300,000 or more, we're going to have a second mediation. And whenever I suggested that to opposing counsel, like at a Rule 26 conference meeting or something like that, they go, yeah, that's a pretty good idea. It is a pretty good idea because if I plan for two, but I don't need a second one, that's great. But if I do need a second one, I don't want to have to come asking for it, and neither do you. So by planning for the second one, we give each other an escape hatch. I think it's hugely beneficial. It's a small but important practice habit that you should get in the business of implementing into your mediation advocacy ritual, so to speak, which is to plan for two mediations in every significant case. Don't let the court set the mediation deadline. That's just an arbitrary date picked by the court. It doesn't bear any relationship to the cash flow needs, the emotional needs, the financial concerns, the life needs of the people that are involved. It's just a date. It's a one-size-fits-all date. That's not something you should live with. You should move the mediation deadline up. All right, let's talk about attendance issues real quickly. If you're in Florida, where I'm from, attendance issues are governed by case law and by rule. You can bring, you have to bring, the authority rules are. If there's insurance involved, you've got to have a representative from the carrier with authority up to the demand or the policy limits, whichever's less. And you have to bring, you have a certificate of authority in state court that has to get filed that says who you're bringing. You can bring other people other than the parties. This is one of those things people don't understand. The mediation rules don't speak to parties, they speak to participants. If you read the Mediation Confidentiality and Privilege Act, it talks about participants. So you can bring experts, you can bring friends, you can bring neighbors, you can bring relatives, you can bring whoever you want to mediation. I had somebody bring their pastor one time to mediation. If it helps them make a decision, okay, fine. Now the other side goes, well, what's going on here? What are these people doing here? They're not parties. Oh, they can't come. Yeah, they can. There's no reason they can't. Now, if they become disruptive, if they become a problem in the process, why as a mediator, I'm going to police that. But you don't need to worry about that on the other side. You say, well, what about confidentiality? Well, they're bound by the same confidentiality rules as anybody else. We explain that to them. So you can bring other people along to help you make decisions, and that's fine. If you really don't like it for some reason, if there's some compelling reason why you don't want that person in the room and they're not a party, then you got to get in front of the court. So what I tell my lawyers is to ask in advance who you're bringing, because we can't deal with this problem at 9 o'clock in the morning. If this problem surfaces at 9 o'clock in the morning, and I've had it happen half a dozen times, y'all didn't talk to each other beforehand. We get there, and all of a sudden someone's in the room and someone doesn't like it, and now there's a big row. And I can't fix that. I don't police that. The mediator doesn't control who participates. That's another myth. I don't determine who comes, who goes, who can stay. That's not the mediator's role. I don't make those kind of decisions. So if you can't agree on who's going to be there, you got to either suspend the mediation and you got to get the court involved. And that's not a good thing to do. So always call or email in advance and just ask the question. Put it on your list, your to-do list, and I'm going to give you a to-do list. Things to do 2 or 3 weeks before the mediation. Email the other side and ask who they're bringing. And if there's somebody on that list that looks funny, doesn't look right to you, then you can have a conversation about that and work it out. And you can get me involved if you want to, because sometimes one side or both don't know the rules, and I'll go over the rules with you and talk about what needs to happen. But it's very, very difficult to get an order striking an attendee simply because you don't want them there. You got to have a pretty compelling reason, because remember, the rule of self-determination says I can bring who I want to. Some judges don't know that. Some judges think that it's limited to the parties. It's not the case. It's never been the case. But some people don't know the rules. Let's talk about Zoom for just a little bit. When Zoom first came on board, there was a lot of hoo-ha about security. That's a non-issue. It really is not a big issue. There was a lot of hoo-ha about, well, how is the process going to work? Are we going to settle more cases, settle less cases, settle fewer cases? And all that now, we've been doing Zoom mediations at the time of this recording for what, 4 or 5 years now. So we've got it figured out. We've got the technology figured out. The point that I stress to the parties, and particularly the plaintiff's counsel, if you're trying to sell the plaintiff, which you are in the mediation process, you got to make sure they look good. You got to make sure they look good, they sound good. I've had mediations where the plaintiff's appearing from some basement in North Carolina and the lighting is terrible, and they're dressed in sloppy t-shirts and sweatshirts and sitting on milk crates. That's not optimal for securing money if you're a plaintiff's attorney. You need to make them look, they need to look good. I wrote an article, you can read it on the website, called The Convention of the Witch and the Princess. And there's all sorts of cultural sort of stereotypes and norms that we associate with dress and attire and appearance and lighting. And if you are, you wear black clothes and you're in a darkly lit room, or your monochromatic clothes in a darkly lit room, that's normally associated with danger or evil. And that's not the kind of subliminal message you want to send to the other side. You want light and bright colors, and you want your clients dressed well and with good audio and good video. And so I tell the claimants attorneys all the time, so the number one thing you guys screw up is you don't have your paralegal or your legal assistant run a Zoom test with these folks. If they're not going to be in your office on a Zoom call, you got to run a Zoom test. Get them hooked up, show them where, get them to where they're going to be, and run it and do a test run for 5 or 10 minutes and see what it looks like and see what it sounds like. Because if it's bad audio and bad video, it has an effect on the mediator. It does. It says to me, you don't care about the process. You didn't spend any time preparing. You're not really that interested in this. That's not the message that you want to send to the mediator. You want to send the mediator that you're a champion for the deal and you've spent a lot of time thinking about this process and you want to get a good outcome. All right. So if there are strangers, and the strangers do become a problem on some level, if I think they're being disruptive of the process or they're interfering with the decision making of the party, then I'll have a conversation with the attorney outside the earshot of the client and the stranger, and we'll have a conversation and say, I have a real concern here. Now, it has to rise to the level of being disruptive or thwarting their decision making ability. If they're just suggesting outcomes, that's okay. You can take advice from somebody else. But if they're really disruptive, I, the mediator, will intervene, and we will either suspend the mediation if we have to, or we'll do something to make clear to the plaintiff or the defendant that they're the one who needs to make the decision. All right. Anything else about, one quick thing. So there's one change to the rule that I think is going to be coming down the pike. We're going to have a new part of the rule that says what mediators can report and what they can't report. And the old rule has typically been you can't report anything other than you reached a settlement or you didn't, unless everybody agrees. So if everybody agrees, then you can put that in the report. But the rules say you're not supposed to report anything other than what the parties say you can report. No commentary, no parenthetical expressions or anything like that. The new rule is going to restate the old rule, but it's going to give you a couple other things to say. It's going to be some rule that talks about whether you appeared or not, whether you attended or not. And there's going to be a part of the rule that talks about terminating mediation. So sometimes mediations, rarely, but sometimes they terminate. So we have an impasse, we have a settlement, we have an adjournment, and now we have a termination. And termination is just a mediation that comes to an end for a reason other than impasse or adjournment. And that could be if somebody gets sick, for example, or somebody has a capacity problem or a medical emergency or something like that. And so we modified the rule to add termination because you don't want to call it an impasse if the person's leaving because they're sick, because that's not really fairly descriptive of what occurred there. So we added this termination language to the rule in terms of what the mediator can report. It adds a level of specificity. Okay, let's talk about dealing with multiple defendants. So part of my career, I had multiple defendant cases. Could be construction, could be an aviation claim, could be medical malpractice defense, all sorts of cases where we have multiple premises liability, or we have multiple defendants. Dealing with multiple defendants in mediation poses some real challenges because it's not a zero-sum game. It's not every dollar this defendant gives across the table to the plaintiff gets. It's a question of getting a number of different checkbooks on this side of the table together to deliver, assuming there's going to be a global settlement, getting them all on the same page so that they can then communicate effectively with the plaintiff in terms of offers and proposals. And what happens is when you add more defendants, it's not just a 1 + 1 + 1 + 1. It's really exponentially more difficult because you're adding 2 or 3 or 4 bodies to the mix. You're adding another lawyer, another client, possibly another in-house counsel, possibly an insurance carrier. So you're going from, what a defense room that might have 3 or 4 people in it to 6, 9, 12, 14, 12, 15. You're getting these multipliers of bodies that have to all buy into the process and think about what needs to happen. That's why one of the reasons why multi-defendant cases get really hard to settle. Oftentimes the plaintiff's sitting there for a long time waiting and waiting and waiting for an offer. And the problem I have is in the defense camp. The plaintiff's not the problem. The problem is in the defense camp. I've got a mediation within a mediation. I can't get the defense to agree on what the proportional share should be and how much who should offer what. And I asked them, did you all meet ahead of time? No. Why didn't you meet in advance? You know this is going to be difficult. You know you're going to want a global settlement. You know you're going to need some kind of consensus. At a minimum, you got to agree on what do we think this case is worth, right? I call it the denominator of the fraction, right? We'll argue about who's in for what percentage shares, what the allocation should be. But if we don't agree on what the case is worth sort of globally, we're really in trouble because, the plaintiff's out here with a $3.5 million demand, and some of the defendants think the case is worth about 2, and some of the defendants think the case is only worth about 1. Well, that's a huge problem. Because if we don't have some consensus on what the aggregate value of the case is, when we start talking about proportional shares, you run into problems pretty quick. If you're talking about 25% of $1 million or $2 million, that's a big delta. So talking about proportional shares isn't really all that useful until we can figure out what we think we're going to pay in the aggregate to get rid of this case. What do you think it's going to take to settle? And those kind of conversations need to take place in advance of mediation. They frequently don't. And I don't know why, because you get paid to talk. You get paid to speak. You get paid to communicate if you're a lawyer, but there's no rule. You see, this is one of the problems with mediation. It doesn't have any rules. If there was a rule that said, in a multi-party case, you got to call all the other defendants in advance and talk about settlement. If that was a rule, you'd do it. But there is no rule that makes you do that. So you have to impose that upon yourself as just a self-governing practice habit. You have to just make up these internal guidelines, so to speak, these internal processes. You have to install them yourself. And we don't. And some of you just haven't learned it. I learned it over 35 years. I know there are things that I need to do before mediation, and there's no rule out there that's going to tell me to do that. But I know these are practice habits that I need to do. It's no different than if I'm going to go jogging. I got to get some jogging shoes. I got to get the right socks, and I got to have the right jogging shoes. I got to check my laces. I got to check the soles if it's a really long run, I got to check the bottom of the soles of the shoes and make sure they're good. And if it's going to be wet weather, I need to have some waterproof shoes. So there's some things I do before I go for a long jog or a run. Right. Just like if I'm going to be in an all-day mediation, there's some things I got to do in advance. And if I've got multiple parties, I sure better have some communications with the other parties before I get there. Because what you don't want is a surprise. Because if you find out someone's taken a zero pay position, or you don't think they've adequately assessed their exposure and their contribution isn't what it should be, and you were expecting them to be in, maybe you thought it was going to be a third, and somebody shows up and says, well, I'm only in for 10%. Not a whole lot you can do on the day of mediation, but if you know that 2 or 3 weeks in advance, there may be some things you can do to move the needle because you can have some communications. You can start to educate them. You can talk to them within the ambit of the mediation privilege and say, I think you're all wet, and here's why. Boom, 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 boom. And you can start doing the finger pointing that you need to do to get their mind in the right direction. Now, you might not move the needle very much, but you might. The lawyer may be saying 10%, but if you're educating them and passing them along information, it's working its way up the food chain, you might find the ultimate decision maker's position starts to soften. And at least then if it hasn't softened by the time of mediation, it probably will by the end of mediation, because it's going to become clear to them that the number that they brought isn't going to be adequate to settle the case. So what you told them 3 weeks ago ends up sort of being right. You understand what I'm saying? So you want to tell them the message early on and then reinforce that message through the mediator during the mediation process. And I'll tell them as the mediator, I don't think you're getting out for 10%. Why did you think that number was the right number? What made you think that? And I'll start reiterating some of the things that the other defendants have been saying to get to sort of soften the position a little bit. And if we don't settle a mediation, maybe we settle a couple days later or a week later. That's okay too. That's okay too. So intra-defendant conflicts and problems are the biggest impediment to settlement in a multi-party case. It's not the plaintiff. If you're having a problem with one of the defendants, get the mediator involved. Call me. Say, I'm talking to defendant Jones. They're taking a little or no pay position. I think that's all wrong. Here's why. And then we'll talk about it a little bit. And then one thing you can do, and I did this later in my career when I started putting all these pieces together, I'm going to call the plaintiff's attorney. If I'm in a multi-party case and I'm looking for contribution from the other defendants, it's not coming, I'm going to tell the plaintiff's attorney in advance. You say, why would I do that? Because you're not being a trial lawyer, you're being a mediation advocate. The no finger pointing rule doesn't apply in mediation. It applies at trial if you want it to. The no finger pointing rule means we don't beat up on the co-defendants. Sure, that's a very common defense strategy, right? It doesn't apply in mediation because you're supposed to beat up on your co-defendants because you want them to bring more money to the table so you can pay less. So that's one of those things where you got to shift from trial advocate to mediation advocate. So I'll call the plaintiff's attorney in advance and I'll say, defendants Smith and Jones are not bringing any money, or they're bringing almost nothing. And I'm shocked by it. And I'm appalled and I'm disappointed and it's awful. And the plaintiff's attorney, having never gotten a phone call like this, you've just got a new friend. The plaintiff's attorney loves you. Thanks. And then he or she's going to say what? They're going to say, well, okay, you've told me they're not. Why is that? And we go through why they're not. Here's what I know. Here's what I think. The reason that they're not paying is this. This is all I know. And the plaintiff's attorney go, what are we going to do about this? I go, well, I guess you need to put some hornets in their basket. You need to inflict pain on them somehow. You need to make the case more painful for them. What could we do? Corporate rep depots, some electronic discovery, motion prep. So what is it we can do to rattle the cage and get them interested? Get the expert report done. Something we need to do to move them off their position, right? So we got to blow some hot air in their direction if we can. And that's what we try. And we have that conversation. And the plaintiff's attorney is going to thank me because he or she now sees me as a champion for the deal. I'm not an impediment to the process. I'm getting all kind of goodwill from the plaintiff from one simple phone call. And have I thrown these other two under the bus? Yes, but they had it coming. They had it coming because they weren't evaluating their case correct. Now, this is assuming, of course, my evaluation of the case is correct, which it always is, right? I mean, that is the fundamental problem here, is that you got to sort of be right. You got to sort of handicap the case correctly and go, I think these guys really have more exposure than they're letting on, and they really need to come to the table with more money, right? But having said all that, I think a phone call to the plaintiff's attorney in a multi-party case, if there's a problem, if you sense there's going to be a serious problem, you tell your own client so they're not surprised when these other folks show up with little or no money. Oh, now you told them this is what they're probably going to do. And then when they do it, you end up looking like you're clairvoyant. When you're not really clairvoyant, it's because you had a phone call with them and you knew this was coming. Clients hate surprises at mediation. If it's bad information, they don't like it, but if they knew it was coming, it's a lot better than bad information that comes out of the blue. Trust me. Worst thing, if you're a defendant, the worst thing your client could tell you, the lawyer, is, why didn't we know this? Good question, isn't it? Why didn't we know this? Right? Well, oftentimes it's because the plaintiff didn't tell us. The plaintiff kind of surprised us, shame on them. But if it's because we didn't ask the right questions, then that's on us. So let's talk about one other piece of the pie here. So we talked about timing, selection of the mediator, dealing with multiple defendants. Um, Position statements need to go out to the other co-defendants and to the plaintiff. There are no ethical limitations, by the way. I've had this come up before. They say, well, if we're, can I talk to the mediator in advance? Is that somehow unethical? No, there's no ex parteing the mediator, because the mediator can't be ex parte. Anybody can call the mediator and talk about anything they want to, as long as they want to, and we don't have to tell the other side that we did it. There's no requirement that I disclose that. Now, as a perfunctory matter, I will typically say something at the beginning of the mediation session like, I've spoken to the counsel, or I've gotten submittals from the parties, and thank you for that background information. So I'll let the parties know that I've spoken to the lawyers and I've gotten some background on the information. But I'm not going to disclose what those communications were. All right. So what else are we going to do? Position statements. I'm a big believer in position statements. If you're a defendant, you get paid to write them. So why wouldn't you? You're going to do a pre-mediation report to the client or the carrier anyway. So you just take that pre-mediation report, you edit it, you change some of the language, and you can ship it out as a mediation submittal. You could do that. That's the quick and easy way to do it. But I think the higher art, the better way to do it, if I'm a defendant and I'm writing to the plaintiff, I'm not writing to the plaintiff's attorney. I mean, I am literally writing to the plaintiff's attorney, but I'm authoring the letter as if the plaintiff was reading it. So my work product should be digestible by the plaintiff, not just the attorney. I don't use a lot of legalese. I don't use a lot of mumbo jumbo. I don't get into the nuances of procedure or summary judgment, blah, blah, blah. I write to the plaintiff. And what do I say to that plaintiff? I tell them we want to settle the case. I tell them we want to make a deal happen, that we're optimistic about the process. Here are some of the challenges that the trial might pose for both sides. And I try to educate them on what, if they're defenses, I try to put them in lay terms, what those legal defenses are. But I try to set my client up as a good person, as a good actor, even though they may have committed some wrong. I try to paint them as in a positive light in the letter. Maybe it's a family-owned business, or it's a corporation with an interesting history, or something like that. I try to humanize my defendant and be a cheerleader for the deal. And I do this in a letter. I don't get too argumentative. And I wrote a piece a while back calling the 10 dirty words you can't use. I don't use words like frivolous or specious or malingerer or sanctions or any of those kind of threats. I don't use any kind of threatening tone in the mediation summary that I send to the opposing side. It's respectful. It might be firm in some parts, but it might be a little tough read in some parts, but it's going to be well written and in a pleasant enough tone so it's digestible. You don't want the party to stop reading it. If they read, well, your client's a liar and a crook, and then you go on from there, I mean, they're not going to go on and read the rest. And I want them to read it, because what's going to happen is the things that I say in the letter, I'm going to say again in the opening, and the mediator is going to repeat. So I want this message to sort of seep in, sink in over time. You've now heard it 3 times, sir. You have a comparative negligence problem. You were driving under the influence. You have a whatever defense I have. You have a problem. This is what it is. And they may not get it the first time, or you accept it emotionally, sort of intellectually. They heard it, but they didn't really get it. And now they sort of get it. It affects the value of the case. So I want to introduce those key themes, those swing thoughts early in the mediation, before the mediation even starts. Then they get repeated during the opening session. And then we hark back on some of those things, some of those bullet points over the course of the mediation process itself. It is a process, right? It's an educational process. I'm trying to educate you, the plaintiff, or the defendants, the other way around. If I'm the plaintiff's attorney, I got to be careful that I'm not sure the defendants are good at reporting all the bad news. Because sometimes it gets filtered, sometimes it gets shaded. Sometimes that deposition went horribly wrong, but the report back to the client was, it was a mixed bag. No, it was horrible. And the plaintiff's attorney can point that out in the letter, and they can cherry pick a few nuggets that may have not gotten reported. So if I'm a plaintiff, I'm always worried that the defendant or the defense attorney is not an accurate reporter of what's going on, or has lowballed the exposure, or suffers from optimism bias. Optimism bias is a big problem. It works both ways, but optimism bias is rampant among defendants. It just is. They think the case is always better than it is. It's more defensible than it is, that the exposure isn't going to be as great as it is. That's just a thing that's built into their anatomy. Because it has to be, because you think about it. If they were the other way, if the sky is falling and it's all gloom and doom and it's all horrible and awful, A, you could hardly live like that. And B, your clients wouldn't want to hear it. So there's always a sort of shading that goes on of the information. So the mediation process is, whoop, we open up the blinds to the big ugly. Okay. We can open up the blinds, but you don't want to do it all at once. You want to kind of just, you're working the blinds up in the mediation through the mediation statement. We're starting to show them some of the ugly. We do it in a professional, factual, non-combative tone. You're not trying to convince a jury to ding these people. These are the people that you're trying to ding are the people reading a letter, and they're the ones who are voting. They're the jurors. They're deciding whether to pay you. And some plaintiffs' attorneys have a real hard time getting their brain around that. They're in trial lawyer mode. And you think insulting them and beating up on them as if like there's some 6 people sitting over here who are watching all this are going to judge. No, the jury is the defendant. You got to convince the jury of the defendants to pay you. So how are you going to do that? Calling them idiots, calling them liars, calling them cheats? No, you got to figure out a different way to. They're engaged in bad behavior. They've been negligent. Okay. Then you violate the standard of care. You need to use the right words, and then ultimately you hope it sinks in. But insults and things like that don't usually work, and pejorative language, not very helpful in my experience in getting corporate actors to do the right thing. Okay. So we want to minimize surprise at mediation too. If you got a bunch of ammunition you haven't launched before, and you save it for mediation, that's a bad idea, because they need time to react to it. They need time to evaluate it. They need time to see if they believe it or not. Surprises are not a good thing at mediation. They're just not. They don't move the needle very much. Let's talk quickly about preparing the client for mediation. You've done the mediation. Well, the other good thing about doing the mediation summary is you're educating your own client, because your client may not have been paying that much attention to the case, but you lay it all out in the summary and they go, I didn't know that. Or you might have got something wrong in your summary and your client reads it in advance. First of all, let your client read it before it goes out. Your client reads the summary and they go, that's not correct. That's wrong. You got that wrong. And then there's a conversation. You've learned something because you've written something in your report that's not factually correct. And so the client corrects you. And that's a good, useful tool. So it gets your client's expectations managed a little bit. The other thing, though, if I'm a plaintiff or defense attorney, I always tell my client, look, there's some things in here that I don't necessarily believe. I kind of hope they'd be true, but I'm not necessarily sure it's going to go that way. So you need to understand there's a little bit of salesmanship in this report. You understand that, right? Okay. Don't believe it all as the gospel when you read it, because some of it's a little bit, I'm shading it a little bit for the mediator and for opposing counsel, but the truth is a little bit different. Make sure the client understands that. Don't meet with the client the day before mediation. You need to meet, depending on the severity of the case, significance of the case, you need to have those meetings weeks in advance, days, weeks in advance. So they know that they're going to have to make a decision at mediation. See, the hard thing for plaintiffs is that the litigation process sort of disenfranchises them from the problem, because during the litigation process, you're the lawyer, you're running the show. You're handling the motions, doing the pleadings, doing the court dates, handling the discovery. Plaintiffs have very little to do, really. I mean, other than producing documents and appearing for deposition, maybe they answer some interrogatories. They're not doing a whole lot, usually, particularly personal injury plaintiffs on a contingency fee. There's not a whole lot going on there. They're just sort of waiting for some time down the road where they're going to have a trial. Because the only thing they've been told is that this is going to go to the jury. If it goes to the jury's going to decide how much I get. Okay. Now, if they watch television, watch movies, the jury decides how it ends. The jury only decides how it ends 1% of the time, right? So how it ends is by, I have to make a decision about whether this is acceptable or not. And the litigation process sort of strips them, pulls them away from the problem or the issue, which is, how much do I really need to settle this case, or how much am I willing to pay if I'm a defendant? What do I really want to do? And the litigation process doesn't answer that question. They don't get any assistance with that. It doesn't prepare them to answer that question. The mediation process dumps the problem back in their lap squarely and flat and says, okay, every mediator says now the case is within your control. It's your time to decide. You have more control now than you're ever going to have. All those things are true. Right. But what prepared them to make a significant economic decision like that? Nothing. Nothing. The only thing that prepares them is you meeting with them and talking about the fact that they're going to have to make a decision with your help. So it really is a hard thing because they don't know how to handicap cases. Even sophisticated business people don't know how to handicap litigation and the risks of what the jury might do and the effective evidentiary rulings and the effective jury instructions and the venue that we're in and all those things that kind of, all that stuff that goes into our decisional calculus as lawyers is foreign to the clients. There's a whole laundry list of things that we sort of think about as we think about evaluating the case, the extent, the severity of the injuries, if we have a causation problem, whether we get attorney's fees or not, all these sorts of things. That whole calculus is very difficult for plaintiffs and defendants. Unless they're professional claims handlers, they don't do it, right? They don't do it. So when you have pre-mediation conferences, what you're really doing is you're putting the case back in the lap of the client. That's a very important thing because they have to own it. They have to own the problem. See, when they give the case to the lawyer takes over. They're shouldering the burden of the process, but that lawyer's not. But there's no decision being made by the client. Very few decisions being made, right? So we're putting the power of decision making back in the client's hands. And if we don't have those conversations and those meetings in advance of mediation, showing up at mediation is going to be could be scary, could be intimidating, could be for some people almost paralyzing because they don't know what to do. And that's one of the reasons why mediation starts slow. That's why people don't, quote, get to the bottom line because they need time sort of psychologically and emotionally get their head around, oh, I've got to make a decision today. I'm a plaintiff, personal injury plaintiff, and I've got to decide. It's me and my lawyer who are going to decide how much we're willing to accept. No one's going to do that for us. I got to decide whether that's enough for me. Right. That's a pretty hard call because you probably have never done it before in your entire life. How many times in their life, if they're a personal injury plaintiff or even a commercial case, how many times in their lives are they going to say, okay, if I'm willing to accept $500,000 today? Probably never. They've probably never made that decision in the history of their life, and they'll probably never make it again. So it's sort of a big deal. And you don't just show up at a big deal like that with no prep, with no advanced conversations, with no communication. This is your decision to make. The mediator, talk about the mediator's role, all those sorts of things. So the mediation statement is sort of introducing the client to the mediation process and getting them dialed in and what I call reacquiring ownership of the problem. Litigation strips the problem from them, the problem of settling the case. It strips it from them. And then you're sort of giving back the case to them, right? Sort of owning the problem. All right. And I have a what is a mediation memo, sort of a mediation guide 101 for clients that one size fits most. It's really well written because I wrote it over 20 years. I think it's really well done because it serves plaintiff and defendants, I think, equally well. And I suggest you pick that up off the resources page on the Henry Mediation website. What is a mediation memo? I think it's excellent. And I think it's in Word format so you can edit it and tweak it if you want to, but I don't think you'll need to do very much tweaking. And then one final thing, don't confuse business acumen or business savvy or sophistication with litigation savvy or litigation knowledge. I've had very sophisticated clients who don't know anything about the litigation process, don't know how to handicap their exposure, but oh, they're so confident. They're confident in their opinion about how the litigation is going to turn out and what's going to happen next. And they're confident people generally because they've been very successful in their lives. So that confidence bubbles over into this domain where, frankly, none of us really know what's going to happen. Right? We're all just best guessers. We're just guessing what we think. Every time we get a case, it's an educated guess. This is what I think might happen. It's an educated guess, right? But it's a guess. And some clients think they can guess better than you. And you have to have a lot of conversation with them to get them to a place where they realize you're not really good at picking horses. This is not something you're good at. Nobody's good at, but you're not necessarily good at this. You've never done it before. And so when I get uber confident people, and I see that in mediation, we start to have this kind of, now, how much litigation have you been in, and why do you think so? And so you've seen this before, have you? And I start sort of ask the same question three different ways, getting to realize they're really rookies. You're a litigation rookie. You're a newbie. Rather than saying you don't know anything, I just get them to think about what their experience has been, which is nothing. And they sort of back into the realization that, oh, this is a place where I haven't been before. Right. I think that could be really helpful. So things you want to discuss, you know all the basics. And again, the what is a mediation memo covers all this. So it shortens your conversation if you want to. What's their role? How can they help? How can they hurt? The role of the mediator. You don't have to answer my questions, those sorts of things. How long it's going to last, how you're going to dress. If you're going to be on the Zoom call, where are you going to be? What's the lighting look like? What rooms you're going to be in? Attendance, who you bring in, if you bring in anybody else. All those sort of things you need to cover in that pre-mediation conference. If you're an insured defendant and you're preparing for that mediation, you're having a little different conversation. If you're an insured defendant, conversation might be are there any claims that are outside the coverage or beyond the policy limits, or are there items of damage that are not covered? Will there be an insured contribution? Is there a settlement control clause? In some professional liability policies, there's settlement control. Is there a hammer clause where if the carrier wants to settle, but you don't, that you end up paying potentially some legal fees going forward, or paying for part of the indemnity later on? So settlement control clause and hammer clauses, that doesn't come up very often, but if it's applicable to your claim, you need to have that conversation. If there's coverage litigation, or there's a real serious coverage problem, we got to have that conversation with the policyholder so they understand what's going on there. And then if coverage counsel is going to appear at mediation, we want to know who that's going to be, and I want to know what they're going to say. And we'll talk about that if we have some time at the end, because coverage counsel can be problematic in the liability case. Let's talk about opening statements. So we've done the position statement. We've shipped it to the mediator and to the other side, and to the other side. It doesn't have to be the same paper you send to the mediator, but you got to send something to the other side, right? Who are you talking to? Is it scripted? Is it unscripted? Is it kind of scripted? I used to just put down, I treat it sort of like oral argument. I had like 3 or 4 bullet points that I knew I wanted to get to, but sometimes I never got to those bullet points, or sometimes because of what took place, like if I was the defendant, something the plaintiff said may have caused me to shift my talk. So, because I'm listening, I'm paying attention, I'm reacting in real time to what's being said. So don't get wedded to your script. You got to read the room. If what you're going to say doesn't seem like it's going to go over very well, if the plaintiff's already crying during the opening, during the plaintiff's presentation, I'm not sure I need to say very much. Maybe I don't want to say anything. Maybe I say something like, I'm very sorry this happened to you, and I hope we can get this resolved. And, oh, would you like a tissue? I mean, you got to be thinking in real time. It doesn't happen very often where you have to go off script, but you need to be thinking about who's in the room and what you're going to say in advance and who you're saying it to. I'm not talking to the plaintiff's attorney, and I'm not talking to the mediator. If I'm the plaintiff, I'm talking to the person with the checkbook. Who has the checkbook? That's who I'm talking to. That's who I'm looking at. I'm maintaining eye contact with the person I am trying to persuade, not the mediator, not necessarily counsel. I had a plaintiff's attorney one time get upset with me because I was talking directly to the claimant, like I was doing something wrong. He didn't like that I was looking at his client. I was looking over here at the client. He didn't like that. Well, why can't I do that? Because he thinks there's some sort of rule that I got direct comments to him. I don't. There's no such rule. There's no such. I talk to whoever I want to. So if you're going to do an apology as a defendant, make sure you think about, yeah, it could be appropriate. I mean, you're admitting liability. Why not apologize? Oftentimes I get plaintiffs and they tell me this in the opening caucus. In the first caucus, they go, they never apologized. It comes up often. They never apologized. Why can't I get an apology? It costs you nothing to give an apology. It costs you nothing. You say, well, it's going to inflate the value of the case. No, it doesn't. Because they're expecting one to come anyway. It doesn't inflate the value of the case. It's just a moral recognition of wrongdoing. See, they're not going to have a trial. If you're settling the case, you're not having a trial. So there's not going to be any public castigation of you. There's not going to be any public shaming. There's not going to be any winner or loser. No one's going to proclaim you to be negligent. So you need to sort of do what the jury would do, which is to admit your negligence. You don't say that. You say, "I'm sorry." It does the same thing. It serves an emotional need that the plaintiff. It helps to get you to the money part. So you're getting rid of the moral component of the case. Now we get to the financial component. We've done that. It clears the deck to talk about money in a way that, if you don't apologize or you say something vituperative, it doesn't help. You got to clear the emotional deck, and you can do that with an apology. And if you're going to do an apology, it needs to come from the client, not the lawyer, because lawyers are paid to speak. It's not authentic. And you got to practice it and you got to rehearse it, because I've had this happen where the client says he's going to apologize. I go, great, fine. And then he starts out doing an apology, and that apology turns into something not like we shouldn't even be here. Like, well, that's not an apology. You turned the gun around the other way. Okay. You know what I mean? That's not an apology. And so and then I'm, wishing I had a steel-toed boot to get my client from talking, and that didn't go well. So we rehearsed the apology, and I tell my client, I go, you got to stick to the script, because if they say something that you don't like and it makes you angry, it may cause you to deviate from the scripted apology, and I don't want you to do that. If you don't want to give the apology after all for some reason, that's your call. But don't change the apology wording, and don't ad lib, because if you're angry, your ad lib is not likely to be good. So try to do the apology with feeling. Got to sell it a little bit. All right. And when do we dispense with opening session? Very rarely. Now, what's strange is if you travel outside the state of Florida, you'll find places where doing an opening session that doesn't occur, or it's the exception, not the rule. In Florida, we have opening sessions almost all the time, but that's just a cultural phenomena. That's no rule that says we have to have an opening session. I mean, there's a rule that says I got to explain the rules governing confidentiality and how the process is going to work, but we don't have to have exchange of opening statements. We don't have to, but we should. I think it's useful. Most mediators agree. Why wouldn't you want to hear what the other side has to say? Why wouldn't you want to eyeball the other side? Wouldn't you want to take a look at the interaction between the lawyer and the client? Hear from the lawyer, see if this lawyer sounds like they know what they're talking about, or are they kind of clueless? That's useful information. So you get useful information in the opening statement. You may not like what you're going to hear, but you get useful information. So I very rarely would dispense with opening. The only time I've done it is in some very nasty cases where there was sexual harassment, pastoral abuse, something really, really nasty where people can get very uncomfortable with the other side in the room. I mean, if you've got a sexual harassment case, don't bring the harasser. That's a pretty bad idea. Or put the harasser back in the other room so they're only there during the caucus. Don't put you don't want to get people all wild, all spooled up in the opening session. So it takes me an hour or two to calm them down so we can start thinking about what we're going to do with the case. It's not oral argument. You're not trying to convince a jury. You're trying to make a deal with the other side. If there's been some legal malpractice that you think they missed a deadline, they didn't do the disclosures correctly, something's gone wrong in the plaintiff's case, you can't bring up the legal malpractice during the opening session in front of the client. You create an immediate problem, because now the client's wondering whether the lawyer's trying to settle the case to cover their own hide. So simple rules: if there's legal malpractice, don't bring it up in front of the client. You can talk about to me on the side, and I can talk it to the attorney on the side outside the client's earshot. And 9 times out of 10, you know what happens? Oh, they say, oh, the defendant's telling me that you missed the statute of limitations on this count of the complaint. And he goes, yeah, I know, I have a problem with that. It's priced into the settlement. The lawyer maybe shaves his fee a little bit at the end. It's priced in. They figured it out. They already know. But if you bring it up in the middle of the opening session, you create all sorts of problems for everybody. So number one rule: if there's legal malpractice committed by one side or the other, don't bring it up in the opening session. Number two, bad behavior. If there's bad behavior by one side in the opening session, I as a mediator can police that to a large extent, but I can't stop them from talking. They say, they're just saying dumb things or saying mean things. Can't really police that all that much. I can shut it down if it gets really bad, but that almost never happens. So I can't really get them to behave in the way that I would want them to behave. They're going to behave the way they want to behave. And if they tend to be kind of snarky, vituperative trial lawyer, they're in what I call trial lawyer, snarky, vituperative trial lawyer mode. I don't really think it's appropriate for me to shut them down. unless they're being verbally abusive, then I could shut that down, obviously. But if they're just being kind of snarky and mean in their tone, it's not good. But the answer is not to return fire. Don't engage. If there's bad behavior, if there's not so great language, don't engage. Let it go. Just don't engage. It's not going to get any better. Um, when I had plaintiff's attorneys barking at my client, saying some mean things and nasty stuff, are you done? Or is that it? Anything else? Okay, well, madam, and I go, Miss Plaintiff, I'm here to make a deal with you today. We're here to settle a case. We're not here to try one. Or something, try to say something to deflect it all and put it back on a more even keel. All right. I don't like big PowerPoint presentations during opening. Most of the time, they're a waste of time. They take too long. Few photos. If maybe it's a construction defect case and you got to show some photos, I get that. If it's something like a medical malpractice case and we're talking about an MRI or something, yeah, okay, I get it. But I don't need long PowerPoints in a case to to figure out what the case is about. 3 or 4 bullet points, and that's all you really need, because no party can digest more than 3 or 4 bullet points anyway. It's true from this talk. You're going to remember 3 or 4 things at the end of 90 minutes. That's it. You're going to remember 3 or 4 things, and the rest you're going to maybe go back and look at the outline and see. But you're going to remember, you have 3 or 4 takeaways. That's going to be it. Well, let's talk about making the mediator work for you. How do you befriend them? Do you want to befriend the mediator? Do you want to get the yes, of course you do. You want the mediator or human beings. So we react positively to positive people around us. So if you call me in advance and you say, Dave, we're interested in settling this case, it look like you're a champion for the deal. Psychologically, that matters, I think. Mediators like people who are trying to be champions for the deal. If I see you're thwarting the process and you're not relaying what I said to the client correctly, and you're shading what I think is pretty obviously not the case, I'm going to have to work around you, so to speak, or work behind you, around you to get to the client. That's a little frustrating. It's a little annoying. I don't get that very often, but occasionally I get a lawyer who's clearly not interested in getting the case resolved for the client. They're interested in litigating the case. It's like, well, that creates a real problem, and I have to spend more time talking to the client about their exposure and the costs and time, et cetera, et cetera. So if you want me to work hard for you, you need to just call me up in advance and say, Dave, I'm here to try to settle the case. That's all I want to hear. And if you send me a mediation statement and it's written in the appropriate tone, it tells me you're a champion for the deal. Don't be in a hurry to respond when you're in with the mediator. Ask questions, get information, use me as a tool for digging information from the other side. Limit your conversations in front of the mediator unless you get stuck, unless you don't know where to go, unless you need some help. But it's perfectly appropriate to throw me out of the room while you're talking in front of your client. If you're on the defense side, let's talk about phone calls and phone calls for increased authority. Of course, you're supposed to have all the authority in the world, but we know that doesn't always happen. So you have to call somebody at the end of the day. We always, as mediators, I always say, don't call unless I know you're calling. And then before you call, let's be clear what you're calling for and how much money you need. Because we don't want to call thinking we need 50, and we don't need 50, we need 75, and we call and we get to 50, and now the 50 doesn't settle the case, and now we got a big problem on the other end of the line. So the other problem with calling is that those folks tend to want to unravel the deal because they weren't here. So they started asking a bunch of questions over stuff we already covered. Like, well, why are we at 400? I thought we were only going to pay 350. Well, why are we at this number? Well, how did we get here? They want to go back and revisit 4 or 5 hours of mediation in a phone call. It's very difficult to do. So what we have to do is we have to pose it to them so it's a deal, no deal situation. So what I frequently say is, I think it's going to take $400,000 to settle this case. You want to pay it, yes or no? And we're not going to revisit. We're not going to spend 3 hours revisiting everything that just happened. This is where we're at. Do you want this deal or no? And so we got to put the person on the other end of the phone. We got to sort of put them in a box. We don't want to give them a lot of wiggle room, and we certainly don't want to set them up to fail. So we want to give them an opportunity to know what it's going to take to get this case resolved. Let's talk a little bit about if there is coverage counsel involved in a case, and I do a lot of insurance work, if there is coverage counsel involved, I want to mention you need to know if the coverage counsel is going to say something during the opening session of mediation, and I'm the liability defense lawyer. So the carrier's hired me to defend the insured. but there's coverage problem or coverage litigation, and there's carriers hired a separate lawyer on the coverage issues, which we call coverage counsel. I want to know if they're coming to the mediation because they want to know what's going on. I'm going to go, well, A, why are you coming? And then B, if you are coming, okay, you are coming, then what are you going to say, if anything, during the opening session? I want to know. And the reason I want to know is because I've been burned. I've been burned before where coverage counsel said something that made it harder for me to settle the case. It may have been consistent with their coverage position, but it didn't help me. If you say, well, there's a fraud exclusion in the policy, well, then you believe there's a claim for negligence and a claim for fraud. Clearly, I'm trying this as a negligence case because the fraud is going to back me into a coverage problem. I don't want a fraud problem. So if you mention fraud in the opening, it doesn't really help because then it gets the plaintiff all spun up. Oh, there really was fraud. I was right all along. Not helpful. Or I've had one coverage counsel say, well, we're going to potentially deny coverage on this claim because the insured lied on the application. Well, thank you very much. That would have been useful information. So I don't have these problems anymore because later in my career, if I saw there was coverage counsel showing up, I go, what are you going to say when you get there? And why are you here? Why are you here? And I guess until I get comfortable with the answer, I keep asking the question. So I don't get burned like that anymore. Okay. The other thing that can happen in mediation, if you're a plaintiff's attorney and you see the insured bringing personal counsel, that means a lawyer that the insurer is paying for out of their own pocket, you want to know as a plaintiff's attorney, why is this person here? Why are they here? Maybe they're here because there's an excess verdict scenario. Maybe they're here because there's coverage exclusions. Maybe they're here because there's something going on that's a little funky. Or maybe there's some non-economic terms of the deal that the carrier doesn't really have any say or control over, and the personal counsel needs to negotiate. Like maybe there's a trademark issue or something like that, or there's some material on the internet that got to get changed, or there's some piece or part of this deal that technically doesn't involve money from the carrier. So that might be why. But you want to know why those if you're a plaintiff's attorney, you remember we talked about call in advance, who's coming, and if that person is an unknown to you, well, who are they? What are they here for? And you might not get all the information, but you get some clue, and that's useful. Okay. What else? Let's talk about the end game and then the pivot to NDR. So we're stuck. What do? We're stuck. If we're stuck, it's usually because somebody is missing something. Somebody's missing some information. Somebody is not satisfied that they've gotten all there is to get. They're not convinced of the merits of the case. That's not usually the issue. It's usually something else. Why isn't this case resolving? Someone has a misapprehension of the facts. Someone is not handicapping their exposure. Someone's failing to consider the potential exposure. There's usually some failure to see the big picture. Maybe they're underestimated the cost to get the case resolved in the courthouse. They think this is a case they can resolve for 50 and it's really going to cost them 100. Or this is a case where they think that the case is not going to exceed the policy limits when there's a possibility it could. And so we've got to spend some time talking about what is it that we know, what is it we assume, what are the facts that we're making our decision based upon, and then we try to poke holes in those things if we can. 60, 70, 80% of the cases that come to mediation settle at mediation. So the odds are pretty good we're going to settle your case. So I'm interested in the 20 or 30 or 40% that don't settle, and why don't they settle? Sometimes they don't settle because we don't have the right parties. Sometimes they don't settle because we brought somebody in too late and they don't have their arms around the case yet. Sometimes they don't settle because we didn't investigate insurance coverage correctly and there's a policy out there. Sometimes there's a coverage position that's wrong that needs to get fixed, and we can't really deal with that right now. Sometimes we have client expectation problems. Sometimes we just have personality problems between the plaintiff and defense attorney, and it's clouding their judgment. That doesn't happen very often, but occasionally. Occasionally I get lawyers that just don't like each other, and they're really, the idea of capitulating doesn't sit well with them, and it kind of bleeds over into their reporting, and it bleeds over into their analysis, and it bleeds over into their recommendations to the client. And so I have to work extra hard to sort of get past that. It doesn't happen very often. In commercial cases, particularly where both sides are paying for their own lawyers, there's no contingency fee. It's not uncommon for the fees to be a problem, right? Small to mid case under $500,000. I mean, you're going to spend $100,000 to try a $500,000 case, and it's not very good return on your investment, is it? No. if there's no fee recovery provision. What most cases are, the amount in controversy is less than $250. I mean, if you take all the cases that are filed in the courts, the amount in controversy in state court, all the amount in controversy, almost overwhelming majority of those cases will resolve for less than $250,000, whether it's personal injury or commercial. They just don't. There's just not that many big cases. So if most cases are going to resolve for less than $250,000, that tells you we really don't want to spend a whole lot of time litigating them. Some cases you can afford to litigate, and traditional legal process might be worth the investment of time. But if the amount of controversy is $300,000 or $400,000 or less, I don't know how you can try the case. You really can't. I mean, chances of getting a good recovery are pretty slim if you're going to pump $100,000 into a trial to get a $300,000 verdict. It's not very good recovery. That's even assuming that you win. So what we recommend in some situations is what we call a neutral-driven dispute resolution. Okay, we've reached an impasse. It's not a big case, but we can't seem to get over the hump here. There's just some factual issues that we can't resolve, or there's some legal problems that we just can't resolve in mediation. NDR, or neutral-driven dispute resolution, is for a category of what I call small to mid-cap cases where the amount in controversy and the interests of the parties don't warrant protracted litigation over a long period of time, weeks, months, and years. And what they need is a neutral to decide the case quickly and effectively. And so what NDR does, it's sort of a stripped-down version of arbitration. Both sides agree on a neutral, usually someone with some subject matter expertise, and the neutral does most of the lawyering. There's no motion practice. There's no motions for summary judgment. There's none of that. It's meant to cut the legal fees down substantially because we eliminate all the procedural hoo-ha. We don't have motion practice. We don't have motions dismissed. We don't have amended complaints. We just get the theory, get the case pled, and then we turn it over to the neutral, and he and she interviews the witnesses, looks at the documents, requests documents. If you file the case, then you have it. So you have a case number, so you can pull subpoenas. You can empower the neutral to have the powers of the circuit court judge, so they can issue sanctions and compel discovery and do those sorts of things. At least issue subpoenas to compel discovery, and from third parties if you need it. And the neutral decides the case. The neutral within the course of 4, 6, 8 weeks, depending on the complexity of the case, and the neutral issues a preliminary opinion. Each side gets to comment on that preliminary opinion, and the neutral can go back and revisit it or talk to some more witnesses or look at some more documents, and then the neutral can issue another revised opinion. And then the process goes over and over until the neutral says, I'm sort of done, right? Or the neutral runs out of money, because you're going to agree on a fixed fee. Usually at the beginning of the process, you're going to try to estimate the number of hours, and the neutral is going to get a fixed fee. So it might be 10, 15,000 from each party. But you're not going to be spending any money you're spending very little money on lawyers, because the neutral's doing the discovery. The neutral's handling the objections. The neutral is deciding what they're going to read, what they're not going to read, who they're going to talk to, who they're not going to talk to. And you can make suggestions along the way, but ultimately the neutral's going to decide the case, and you do it for a fraction of the cost of traditional litigation. Neutral-driven dispute resolution, NDR. This is invented by a guy named Rob Christopher out in California a few years ago. He wrote a book about it called Just Resolve, neutral-driven dispute resolution, and he and I then co-authored an article that appeared in the Florida Bar Journal back in 2024. So if you want to know more about NDR proceedings, and particularly how they work in commercial cases and business disputes, just Google neutral-driven dispute resolution, Henry and Christopher, and you'll get that. That article will pop up, or it's probably on my website at henryadr.com. It's in the Florida Bar Journal. So that's a little bit about NDR. I like to recommend that to the parties, particularly in small to mid-cap business disputes where the lawyer's fees could quickly gobble up a lot of the money that's in controversy. I think that's pretty important. Let's talk real quickly about drafting the settlement agreement at the end of the day. We need to be careful when we come to mediation, in that when we create a settlement document, do we really mean for this to be the full and complete settlement, or are we contemplating a longer, more drawn out, belts and suspenders settlement document? Frequently in mediation, we don't really do a settlement. We say we've settled, we have a bullet points. You're going to pay X amount of dollars in X amount of days, and you're going to release the claims. But the real paperwork's coming later on, correct? So the mediated settlement agreement is not really a complete document. It anticipates another longer document, yes? So what you really done on mediation is an agreement to agree. We don't talk about that very much, but in truth, you really haven't made a binding settlement because you've got another document that has to be agreed later on. Well, what if that other document isn't agreeable? What if there's some language in another document, the language of the release, or maybe there's some other things that got to get done, like easements have to get extinguished or transferred, or some intellectual property rights have to get transferred, or some fences got to get moved, or there's other things to the deal that got to happen later. And for whatever reason, those things don't happen, or the language, you can't agree on the language. You don't like the phrasing of the release or the hold harmless or whatever it might be. So the mediated settlement agreement that you reach on Friday afternoon contemplates another document. Then I take the position you really don't have a settlement on Friday afternoon. Now, nobody wants to hear that. But legally, you got to be very clear on what you've done on Friday afternoon. Have I created a legally binding settlement agreement, or have I really created an agreement to agree? And if it's an agreement to agree, which 9 times out of 10 it is, because there's more paperwork coming later on, then what you've really done on Friday is you created a term sheet, an unenforceable term sheet. It says, this is what we think the deal is going to look like. We all agree these are the main pieces and parts of the deal. But then, of course, what happens on Monday and Tuesday is somebody remembers something, or somebody brings something up that we didn't talk about on Friday, and they inject it into the deal, and all of a sudden, oh, we didn't talk about that on Friday. It's like, well, yeah, we didn't. So what? We didn't make a deal on Friday. We were close to a deal. We got right up to the altar, but we didn't really make a deal on Friday. And so if I'm adding something new, it's okay. And I know it's upsetting to you and your client, but legally, I haven't done anything wrong, and there's no breach here. I haven't breached anything in either of you, because we didn't really create a binding agreement, and nobody wants to talk about that. No, mediators don't talk like that. They don't want to talk like that. They want everybody to think, well, you made a deal, and I'm going to hold your feet to the fire, and that's useful for the clients until it's not. Until you have a real problem with the settlement documents, somebody sticks something in the settlement documents that we hadn't contemplated, and now we got a big hoo-ha. And I've had this problem a half a dozen times in my life. It doesn't happen very often. When it does, we're all now saying, okay, did we make a deal on Friday? And if we didn't, then okay, I can add a new term. If we did make a deal, if one side says we made a deal on Friday and the other one says we didn't, now we're litigating over whether we made a deal or not, which is another mess. So in my view, that's like mediator malpractice. I'm not letting you leave my mediation unless you have a very clear understanding about whether you have a deal or not. I feel like that's my role as a mediator. If you leave my mediation, then you later have an argument about whether or not we had a deal on Friday. To me, that's like going in for surgery and they cut off the wrong arm. Well, take out the wrong kidney. That's like malpractice on my part. You can't leave my mediation not knowing very clearly whether you have a deal or not. That doesn't make any sense to me. So in my world, any competent mediator ought to tell you very clearly, okay, you understand we have a term sheet here, right? This is not an enforceable mediated settlement agreement. It's probably going to become one 99 times out of 100. You guys are going to do the paperwork the next week, and then you're going to button this thing up. But understand, when you leave here today, it's not really a binding, full, complete settlement. People don't want to hear that. They certainly don't want me saying that in front of their clients, and I don't. And I don't. What I do say is something like, I think what we've done here is create a term sheet, and we call it a term sheet, and we sign on it for whatever that's worth, if you want to. I say it doesn't really matter if you sign it or not. It's just a term sheet. It's not binding. The settlement agreement you're going to do next week, now that's going to be binding when it gets signed. And folks don't like that. Well, there's a simple solution. Then bring your settlement documents to the mediation. But sometimes you can't because things come up and you haven't anticipated. But bring your documents to the mediation in advance. Think about, what is this deal likely going to look like? You can get 90% of it done in advance, right? So it's not a large typing exercise on the day of the mediation. Sometimes it is. Sometimes you just have commercial cases, multi-party cases, and there's lots of weird pieces and parts. There's provisions about going forward, business deals, terms, other documents that got to get signed. Maybe there's, no trespass requirements. There's non-competes. There's whatever there might be. It could be harder drafting. Okay. Then you just know that you didn't make a deal that day, but you're fixing to make one pretty soon. That's pretty important. So I want to make sure we understand the difference between a term sheet and a fully enforceable mediated settlement agreement. Okay. let's talk about, in closing here, some key swing thoughts. Position statements got to go out 2 or 3 weeks or more in advance. The bigger the case, the earlier the position statement needs to go out. Because if you're a plaintiff, you want that position statement to go up the food chain. It may take a while for it to get up the food chain. If you're a defendant, you want to give the other side time to digest the information. If you're giving them a lot of bad news, they need time to process it and digest it. And tone is almost more important than content. So a detail-oriented but carefully worded, thoughtfully worded position statement is useful because it sets up the things that you're going to talk about during the opening. It sets up the things that the mediator is going to talk about through the day. And I call it like you're tenderizing the meat, or you're marinating. You're putting the plaintiff in the marinator. If you're a defendant, you're sort of tenderizing the meat. You're sort of starting to tap on the glass a little bit. In a multi-defendant case, you got to have that multi-defendant powwow 2, 3, 4 weeks before the mediation, because if you got someone who's taking an irrational position, you got to work behind the scenes to see if you can change that. And you need to know in advance what those people are likely to do on the day of mediation. No good coming in and being surprised. Your client's not going to like it. If you get in trouble, or you get confused, or you get into some weird ethical territory in a mediation, it's okay to phone a friend. I get calls sometimes, not very often, but once in a while I get a call. Hey, I'm in a mediation. I got this going on. What do I do? Or when I was younger, I had this happen a couple to me times, and I couldn't get one of my senior partners on the phone. So who do I call? Somebody. Call somebody. Don't just freeze and do nothing, or do something makes the situation worse. Take a break. Say, mediator, I need to take a break. If you need to be away from your client because your client's the problem, you say, okay, Mr. Mediator, I want you to go tell my client to sit in that room and watch them and don't let them leave. And then I'm going to go over here and have a conversation with somebody else. Get them a soda, get them crackers, but I'm going to go have a conversation over here, and I'll be back. And you don't have to tell everybody what you're doing. You just say, I need a break. All right. And then you go have that conversation, phone a friend and do that. Perfectly. And then if you really can't get if things just seem like they're becoming sort of off the rails, you feel very uncomfortable about the process, just ask for an adjournment. Again, people may not like it, but sometimes an adjournment is an appropriate thing to do, just to give yourself some time to figure out what's going on here. Maybe there's some legal malpractice issues. Maybe there's some coverage problems. Maybe the mediator's acting inappropriately. You just adjourn the mediation. Don't let bad behavior from opposing counsel, or vituperative language, or whatever, any offense from the other side, cause you to lose sight of the objective, which is to get the case resolved. It's really easy to get caught up in that stuff sometimes. You get all jazzed up, but don't get caught up in that. Stay focused on what is the mission here. The mission is to get this case resolved despite the bad behavior from the other side. Schedule 2 mediations, not 1, in significant cases. Mediate the case earlier in the life of the dispute. Do not rely on the court-imposed deadline. There's no reason to do that, because it's not sensitive to your client's needs. If you're a claimant, you want to get paid. If you're a defendant, you want to stop paying attorney's fees. So give your clients the opportunity to settle out early. You don't need a phone book to settle a case. You don't. There's a minimal amount of information that you need. You need to have you need to have a grasp on the 4 corners of the liability claim. You got to have a grasp on the damages. You got to have a little bit of sense of what your exposure is, ultimately, what your wat and a batten is, worst day, best day. But other than that, you're going to be making a decision with imperfect information anyway. It's always a best guess. So get into early mediation. Invariably, if you don't settle your case, you're probably going to learn something new. You're probably going to learn something that helps you in the litigation process. Maybe you come up with a new theory. Maybe there's an expert. Maybe there's an item of damages you didn't really know about. Maybe there's a witness, or there's another party I need to join. There's a number. I can't tell you how many times I've been to mediation where we stumbled upon, during the course of 5, 6, 7, 8 hours, we stumble upon some new information. The client tells us something we hadn't heard before. Not an uncommon scenario. Because when are you going to be with your client for 4, 5, 6, 7, 8 hours? Like never, right? When are you going to be noodling on one case for 4, 5, 6, 7, 8 hours? With your ears, your eyes focused, phone off, focusing on one case. Well, you're bound to have a revelation. You're bound to get something new. So that's why I like early media. I don't care. I had a carrier tell me one time, said, Dave, we don't care if we settle the case or not. We want to get in early and get an assessment of our exposure. We want to look at that plaintiff. We want to see that plaintiff's attorney. We want to get a sense of, are they really serious about that number? Because it gives us information. We get a whole bunch of information in the mediation. That was the smartest thing I'd ever heard. Carrie used to say, David, we don't need a bunch of discovery. Get this case in the mediation. We'll figure it out when we get there. And if we settle the case, great. If we don't, that's okay too. But we're giving ourselves a chance to get off this bus. And that's what we want. And plaintiff's attorneys should be receptive to that. And so you say to them, we're going to go to early mediation. It's a policy of the firm. We do it all the time. And tell me what you need from us, and I'll see if I can get it for you. Because I can maybe send you some things within the ambit of the mediation privilege. Like if I have a preliminary, like plaintiff's attorney says, I want to depose your expert. You don't need to depose my expert. You want his preliminary report? I'll give you the preliminary report under the mediation privilege. You can't use it in the discovery, but I'll give it to you, the preliminary report as a mediation communication. I can get some documents to you informally. All right. What do you want? What do you want? What do you need to mediate this case early? And if you have that conversation, you show an interest in settlement, I think the plaintiff's ears would perk up. Should, right? And if you're a plaintiff, same thing. Tell me, defendant, what do you need to be in a posture to mediate this case? What do you need? So think real, and they might not have a good answer for you on the phone. So call them back a couple of days later. What do you need? Or phone, email. What do you need? But we want to set an early mediation. And between now and the mediation date, I'll get you as much of this as I possibly can get you. Right. So early mediation is better because you get information even if you don't settle the case. Thank you for your attention. If you want the course number again, I'll give it to you. It's 250740-6N. If you go to the website, you're going to find what is a mediation memo. You'll probably find a mediation countdown, which gives you some steps and some things to do in advance of mediation. You're going to find the Mediation Mastery Series, which is 5 hours of CE, covering a whole range of deep dive into a whole bunch of different topics that are related to mediation, client-specific, case-specific kinds of scenarios that I think will be useful, rules, ethical problems, all that sort of thing. And I hope you will avail yourself of that opportunity. Thanks for joining us, and see you down the road. Take care.